Mr. Deputy Speaker, sir, the very outset, I would like to thank the Leader of Opposition, Dr. Conrad Sangma, and the Honorable MLA from Dadingri constituency, who have moved the resolution that whereas the illegal immigration and uncontrolled influx in the state remain a major concern, and whereas to address this concern, there has been a collective resolve by the political parties and all stakeholders in the state to prevail upon the Government of India to implement ILP under the provisions of the Bengal Eastern Frontier Regulation 1873 through a resolution adopted in this August House. And whereas Government of India has not shown any positive response to implement ILP in the state till date, and whereas the state has legislated its own law to deal with the issue of illegal immigration and uncontrolled influx, the MRSSA Act 2016, and whereas the MRSSA 2016 provides comprehensive legal framework to regulate the entry, exit and stay of people from outside the state in order to ensure safety and security of the citizens, including identifying entry-exit points along the interstate border and establishment of facilitation centers. And whereas the state authorities have identified parcels of land for such entry-exit points and establishment of facilitation centers in order to give fruition to the objective of MRSSA 2016. Now, therefore, this House do resolve to urge the government to complete the whole process of establishment of facilitation centers at the identified entry-exit points with proper guidelines and to put in place all other regulatory measures as per the mandate of MRSSA 2016. Mr. Deputy Speaker, sir, I would once again like to thank the Honorable LO for having brought this resolution. I think there is no doubt, I would not even use the word I think, I would rather say that there is no doubt that when it comes to illegal immigration and protection of our people and the protection of our land, it is the top priority of every single member of this House, and I'm sure every single citizen of our state. Let there be no doubt about that intent and that desire to ensure that there is no illegal immigration in our state. For the government, this has been one of the most important agendas to ensure that we are able to create a mechanism to be able to protect our people. For that, we have done multiple actions, and I will speak about them a bit later. But let me start by mentioning, sir, that the intent, the same intent that we all have, the same intent is the intent with which the then government had come out with the MRSSA 2016. So it's very clear, sir, that the intent was very positive, the intent was very good, and the intent was correct. But while that intent is there, and as correctly mentioned by the Honorable Leader of Opposition, we are confined And we work under constraints of multiple acts, multiple laws, provisions made by the Parliament, provisions in the Constitution, and having to create a law to navigate through these complexities is really where the challenge lies. And I would like to dwell upon that for a moment. So let me go back to the court, the High Court order, which was given on the 2nd of December 2021 in regards to the MRSSA. So the Honorable High Court noted, and I'll speak very slowly, sir, because this is very important words. The Honorable High Court noted that the provisions of the MRSSA, I mean 2016, are omnibus in nature, in as such as specific parameters for restricting and regulating the entry or movement of citizens at the entry and exit of Meghalaya were not specifically provided in the Act. This is the High Court order, sir. It says again, is that in as such as specific parameters for restricting and regulating the entry or movement of citizens at the entry and exit of Meghalaya were not specifically provided in the Act. And therefore, the Honorable High Court stayed the operation of such provisions during the course of the pendency of the PIL. Sir, again I go back to the point that we have to go through the entire scrutiny of court. The Act must and will be scrutinized by the judiciary. And that is exactly the challenge which the MRSSA faced. And as I was mentioning earlier, sir, that the court specified that the entry and exit were not, the parameters for restricting and regulating the entry or movement of citizens at the entry and exit of Meghalaya were not specifically provided in the Act. This really placed or put the challenge in front of us. And accordingly, the government, the judiciary stayed this operation, and we had to close down the entry-exit gates that we had constructed and the facilitation center that we had created. That is the first case that happened. Consequently, sir, we approached the High Court again, and as you all know, we were right in the thick of COVID-19, the pandemic. And in that particular case, we went back to court, and the High Court observed that the use of the facilitation center was limited for identifying and screening persons, whether they were afflicted by the dreaded disease of COVID-19 or not. I repeat, sir, the use of the facilitation center was limited for identifying and screening persons, whether they were afflicted by the dreaded disease COVID-19 or not. This aspect came to be noted by the Honorable High Court in its order 22nd of February 2022. And at the end, the PIL, the earlier PIL which was filed, was disposed by an order dated 27th May 2022, was disposed in view of the fact, so this is the most important part, in view of the fact that the relevant facilitation center were handed over to the health department for checking of coronavirus infection. So technically, it was more of a health concern that led to, and many states were, in fact, doing this aspect. And court specifically mentioned, sir, I will take the time to to specifically read out what the court, in fact, ordered in the second order that it said. And the court order says that the checkpoints are in place, but it does not appear that anything untoward is being done for it, or the periodic checking has resulted in any serious impediment to free passage. So that the periodic checking has resulted in any serious impediment to free passage. So nothing appears to be there. This is what the court says. That is checking the free movement of individuals. Indeed, the petitioner says, that is the government, that the relevant gates have been handed over to the health department for checking for the coronavirus infection. And the activities at the gate were restricted to the same. The activities at the gate are restricted to the same, which means checking of coronavirus. Accordingly, the PIL number 13 is closed. Hence, the PIL at that point was closed, not because the court agreed to the provisions that were there or the provisions which were not there in the act, but because government at that point had said that these gates are, at that point in time, we were at the height of coronavirus, and that check gate was handed over to health department for entry exit. So I just wanted to clear the air around what the court has been saying. Sir, also, just to again add, sir, to what the court has mentioned again, that as per Article 19, subclause 1D specifically provides that all citizens the fundamental right to freely move throughout the territory of India. However, for the purpose of India, this fundamental right is subject to reasonable restrictions under Article 19, subclause 5 of the Constitution. However, for the purposes of the said section to be provided, reasonable restrictions, specific parameters must be identified when the movement of the citizens can be restricted. The Honorable High Court of Meghalaya has noted that these specific instances are not provided in the MRSS Act 2016 as far as the facilitation centers are concerned. So, sir, we faced this kind of a situation where there was a lot of legal scrutiny as to the provisions that were there in the Act of 2016, and obviously as per the rules that were then created. And this is not our interpretation, the judiciary interprets, and this is the High Court that interpreted what I just mentioned to you, sir. And hence, we were in a very difficult position to continue with the facilitation center or to activate any of the facilitation center, because the High Court completely has struck down the whole thing, saying that there is no specific, that there has to be certain specific parameters for identifying the restrictions and providing reasonable restrictions. We have to specify those purposes and instances, which is not there in the MRSSA Act. This is the interpretation of the court, sir. This is not my interpretation. So I just wanted to clarify that one point. So second, I think it's also important to take one step back. Now, what is the MRSSA objective? And Honorable LO will be in the best position to give more light on that. But apart from many other aspects, which I don't want to go into, there were two main agendas that were to be achieved by the MRSSA. First agenda was, of course, to have a mechanism for entry and exit, to be able to check who's coming in and are they going out. That was the first one, and based on that, the facilitation centers had to be put up. But the facilitation centers that were put up for the entry-exit did not stand the test of or the scrutiny of the judiciary. And I explained, sir, that the only reason why the PIL was disposed of at the second phase was because it was handed over to the health department to act as a screening point for COVID-19. The second purpose was to then, of the MRSSA, was to register and keep a track of people who are coming into the state. Now, that of course is an area where activity is going on, sir. And just so that the House is aware that till February 14, 2026, 817 localities and 427 sub-localities have already been registered till date, sir. So this process is on. I take the suggestions of respected and honorable members. Our honorable member from Dading has suggested that we should start the exercise in other parts of the state, in Jayante Hills also, in Garo Hills also, and I definitely take this suggestion as a positive suggestion. And definitely, sir, we will move into that aspect also. So the second part of getting the registration and monitoring the people who come and stay in rented houses or different accommodations, and training the different headmans or nokmas or development committees, so on and so forth. This aspect can definitely continue. And I can assure the House, sir, as I said, if the Honorable LO will remember, that this was in fact discussed many times before also. So in the earlier first few phases which we had taken up, in the first phase, sir, we had only 9 localities. This was right at the beginning, sir. As correctly mentioned by Honorable LO, that 2016 the law was passed, and of course 2 years, for whatever reason, nothing was implemented at that point in time. But 2018, as soon as we came in, sir, we implemented. We started putting all the things in place. We started putting up the facilitation centers. And that's when the court came in and they struck it down. And of course, in the beginning, sir, there are rules to be made, there are lands to be acquired. So it's a process, I can understand. So the process happened. And by 2018, we started the process and we started engaging with the localities. And I remember multiple times this was brought to the House. So in the first phase, only 9 localities were taken up. Then there was a suggestion from the House that no more should be done. We went to the second phase. Then we took up 7 more localities in the second phase. Then, of course, more pressure came that no, this is not enough, please do more. And I gave an assurance to the House that we will do more. And I'm happy to tell you that in phase 3, all the remaining localities in Shillong area, including Shillong Municipal Board, Shillong Cantonment Board, civil subdivisions and different blocks, we have then created the different bodies that are there. The technical words are forgetting. So that the technical headed by Deputy Commissioner. So these committees were set up and slowly and steadily we started to expand. So in the third phase, after I gave a commitment to the House in the last session, I can't remember. So activity has picked up because we are learning, sir, as we move along. This is not a regular exercise. It requires a lot of coordination. Every locality, there's a different condition. Different leaders are there. Some support, some don't support. Some do support, but then they don't do the activity. They come for the training, but then they have to be pushed to again continue with the registration. It's a very tedious and complicated and not an easy exercise as it may sound. If it's automatic and everybody takes responsibility, which I hope that this kind of resolutions will send that message to the public, that this can only happen if all of us work together. If all citizens, publics, nokmas, rangbashnongs, everybody has to put in their effort. So, the question comes in that, okay, now we'll do this, but who's going to pay us to do this? So, we don't have provision to start paying every locality an amount every month to have a data entry operator to enter this. These were discussed, sir, and these are factual matters. So we actually had to motivate them, saying that this is for your own good. So you must do this. So when we started moving, they said, well, give us computers. We don't have computers. So we can do for 100, 200, 300. But we have maybe close to 7,000 listed villages and maybe more than 12,000, 15,000 smaller villages which are there. So that's why the exercise is very complicated because it requires a lot of logistical support. And sometimes we don't get the kind of response at the grassroots level which we all would expect. But my point being that the second part is something that we are moving. And we will continue to move, which is the registration part and monitoring part, which I feel is a very, very, very critical and very important part of the Act. And this is something that we will continue to pursue and ensure that this happens. And as I said, I assure the House and the members that we will take special interest to ensure that in other regions, especially regions where there is more economic activity, there is more movement of migrant workers, maybe, so on and so forth, that we will take up this activity there. And I take this suggestion in a very positive way. And I assure the House that, that we will definitely go into this aspect, sir. Sir, apart from that, again, as I said, not to undermine the MRSSA in any way. As I said, the intent was correct. But as you saw, sir, the court has made its observations very clear. I don't want to repeat the language, but it has put that restriction right now. And because of that, sir, we are not able to move forward. And that's the reason why we went for the amendment. So that because we already knew ahead of time that this is going to be a tough point. The fact that the amendment did not go through, therefore, it did not impact the court order. The court order came out based on the 2016 Act, sir. It did not come out on the basis of the proposed amendment that we were thinking. And ultimately, the proposed amendment also did not go through because we were hoping that we'll be able to give more teeth, as mentioned by LO, to this Act so that we can actually pass through that test of the judiciary, which is what we got stuck with. And of course, there were multiple challenges. We know what happened. And because of that, ultimately, this ended up in MHA. And also, I want to just share with all of the members of the House that when this went to MHA, the written reply that came to us from Government of India was that the proposed amendments in the bill appears to have outreached the original intent of the MRSSA by seeking details of all persons rather than only tenants already residing in the state, entering into the state and providing for punishment for not doing so. So the proposed amendment bill appears to be violating Article 19(1)(d) and E of the Constitution. Now, so we had to do this. We had to do this because of the fact that the rules that were created and the desire of the people was to be able to check every single person coming in. And we were not able to do that based on the existing law and the existing, well, the rules said that we will now check everybody, but provisions in the law were not there. The provisions of the law stuck, as Honorable LO will know, stuck to criminals who are there or tourists who are coming in, so on and so forth. But as I said, that also had to be mandated in the Act itself. So that's where the clash took place. That's where the confusion took place. That's where the complications came out. And that's why we were not able to take things forward. As I said, sir, the original Act with its right intentions was absolutely in the right direction. But as I said, because of the different aspects and different conflicts with the law at the national level and also the observations that we got from the High Court, we were not able to proceed. And hence, as suggested, we need to make some amendments, but we are still in discussions with Government of India on that matter to be able to take it forward. And that's why, sir, we thought that this checkpoints and entry-exit points that we have been trying to put even through the MRSSA, which did not stand the test of judiciary. We thought that through the Foreigners and Immigration Act 2025, we should be or we will be able to get an option to implement that. So that's how things are moving, sir. We are exploring all options. And as I said, what is important to remember, which I mentioned even yesterday, sir, in my opening remarks, is that when we talk of any law or any act, and we say we want this particular act, so that creates a point of position for us. So what is our position? Our position is ILP. Whereas, it is important for us as a government and as a legislature to look at what is our interest. What do we desire to achieve? Not our position, but what we desire to achieve. Because desire to achieve is a mechanism to check illegal immigration. That's our mechanism. Or to check the influx, or to check the people coming into our state. That is the issue. Now, ILP or MRSSA or Foreigners Act in mix or as individuals may help us achieve that goal. But we are facing challenges in all of them, sir. So if part of this is happening through the MRSSA, somewhere we are trying to push ILP, we took the resolution showing our intent that we are serious about it, that hopefully we'll get the ILP, and we're still pursuing it, sir. The third part we're looking at in the Foreigners and the Immigration Act 2025, which I hope will be able to give us that provision which we require to be able to achieve this objective and this issue, resolve this issue of having that mechanism to check influx. So I think this is very important for the House to understand. So we should not. I think in the past also, sir, without going into details, Honorable LO will remember, sir. And I don't want to go into details because I understand that's how positions change, situations change. But there were arguments even between, Honorable MLA, who is not here today, of Nongkrem and Honorable LO when he was Chief Minister. When they did not agree that no, one said we should have ILP, then the other said no, we should not have ILP. To the extent that the LO had even said that then CM had said that, you are changing your stand now. Earlier you said you want ILP, now you don't want ILP. So my point being, sir, that our positions can change. It's natural, sir, because we start to understand the pros and cons of a certain position. So what I'm trying to tell the House, sir, is that we should not be driven by a position. We should not be driven by the fact that, oh, I will not change my stand, ILP is my stand. We have to realize that we need to achieve our goal, not to win on our stand. Our goal is a mechanism. So how do we change? And therefore in the past also, and for me also, sir, sometimes I see plus in it, sometimes I see minus in it. My position changes based on what I understand better of the situations in the law. So these things happen, sir. But my larger point that I'm trying to make, sir, is that as legislatures, we need to go beyond position. We need to go beyond position. Our positions change in the sense that today I say that ILP is good, tomorrow I may say ILP is not good, day after I may say no, for Foreigners Act is good, I may not say it's not good. So those can change, but our objective remains the same. So I would like to urge the House that we should think in that positive term, be united in our efforts, and work towards that common objective of creating that mechanism to achieve that final goal, sir. Having said that, sir, what do we do with our laws and regulations is obviously a mechanism that we'll put in place. We're working towards that. We're doing our thing, our work, and trying to improve that, which is a continuous process. But at the end of the day, what is important is to remember that we have a larger socio-economic issue. Whether you talk of illegal immigration, or whether you talk of unemployment, all of the other aspects, so these are all connected together. And at the end of the day, it is only by finding long-term socio-economic solutions. Number two, in the long run, ensuring that every stakeholder at every level plays their role and takes their responsibilities seriously. Only when these two things come together will we be able to find a long-term solution to tackle illegal immigration, sir. So that's one thing I wanted to say. Now, what do I mean by long-term, sir? So when you think of long-term, correctly as mentioned, today, why do illegal immigrants come into our state? If you talk of a person from Bangladesh, for example, wants to come in and starts, sir, they don't want to come to our state because they want to vote here. They don't. They're coming in here because of economics. They're coming in here because they're getting a job. The Honorable MLA from Dadingri mentioned that there were some individuals in a certain incident who are from a different country. Why did they come here? Because of economics. It's not they want to vote. But at the end of the day, they realize that the only way to earn and be able to get economics is to be able to get identity and be a voter here. Whereas if you look at many, many developed nations that are there, what do, sir? They create, and I spoke about this about, I think maybe about 10 years, almost 8 years back, sir. That if you look at other nations, I'll give example of Australia. They give you what they call a work permit. You can work, you can earn, you pay taxes, you can do everything in Australia because they don't have enough manpower, say for doctors, for nurses, or other skills that are required out there. But what does Australia say? You can do everything and you are Australian in every sense, but you can't vote. But you can't vote. So that is how they created their system. I'm not saying we have to do it, but I'm just giving an example of what Australia did. They created a work permit because they said, look, we need manpower. We need to have workers. We don't have doctors. We don't have enough nurses. Our population is aging, so on and so forth. So they gave work permit, got best doctors, paying them well, but they will never be allowed to vote. Never. They'll never become full-fledged citizens. Now, what I'm trying to say, sir, in the long run, we have to realize that it's a socio-economic issue. Till the time our youngsters are not able to provide the similar skills that maybe people coming in from outside are providing. Like we had a big problem, and we always have a big problem of mistri, we call. I think so you also must be having similar problems in terms of, even the houses or even your constituency work. I think every MLA must be suffering, especially Garo Hills. That as soon as there's a situation where there's a communal tension, we have very few people who are there to work in terms of masonry or mistri as we call it. So hence there's a need for our people to develop that skill, to be an alternative or be the primary providers of that kind of a service. I'm not saying that we take away people's jobs, but I'm saying that somewhere along the line in the long run, we need to work in that. So skilling is very important, correctly mentioned. Number two, sir, we need to develop entrepreneurship. At the end of the day, an enterprising economy, an economy where youngsters take calculated risks, build up businesses, and provide opportunity to local boys and girls, that is how an economy moves forward and economy changes, sir. And therefore, it's important that we push entrepreneurship. We have, in fact, as a government, we took initiative because we realized that there is a lot of problem of migrant laborers. So you must be remembering, sir, we came out with the Meghalaya Identification, Regulation, Safety, Security of Migrant Workers Act 2020. This was again done to provide that, again, mechanism to be able to have some kind of a registration and check for migrant laborers and migrant workers. Now, it's not perfect, again, as mentioned by Honorable LO. But we take initiative. We work out. We take steps. Sometimes it doesn't work. We amend the law. We move forward. We take suggestions from people. But I think the intent has already been cleared, sir. We are all for it. And we want this to be a situation where we are able to find the right mechanism. MRSSA, as I said, has got two major sections to it, or rather two main objectives, apart from many other. The first one being the entry-exit is facing challenges because of the fact that it does not test, it's not standing the test of judiciary, and I've read out the orders of the court. In the process, we are looking at how we could amend and move forward, but again, we are facing challenges there too. So while that continues, I don't want to use the word battle, but while that battle continues, I don't have a better word right now, but while that battle and that situation continues, the fact that the MRSSA, the second part, which is to do the registration and empower the local bodies, is definitely a welcome suggestion, sir. And as I said, we are moving forward in it. It's not that we are not. Every time the honorable members bring this subject out, we go even one step further. But I've told you the problems we face because it requires a lot of pushing, a lot of logistic support, a lot of monitoring. And obviously, as administration, there are multiple tasks to be done. So sometimes we, call the meeting, request. Some do it, some don't do it. Some localities take interest, others don't take interest. So it's a very, very complicated process to motivate people to do, but doesn't mean we won't try. We are trying, we have succeeded to a large extent, but I'm just appealing through you, sir, that if honorable MLAs, if honorable local leaders, if local locality traditional heads can also take that step and initiative to say, look, let's work with the government. Let's not just say this government's job alone, because ultimately it affects all of us. So let's work together. I think that could be one of the very, very positive outcomes of this discussion today. So through you, sir, I appeal that the MLAs and the legislatures, the legislatures and the public at large and the traditional heads and especially the locality heads, if they could work with the government in a positive manner and support in the logistical support that is required. Government also will do whatever is possible, but government cannot do everything. So therefore, in that we require the support. As I mentioned, they're requesting that if there can be salaries be paid to one data entry operator in every locality, so that data entry can be done and an office can be set up, to office to be set up in all the localities. Computers and other infrastructure be given to all the localities. So we can do it in a phase-wise manner, but as I said, there are challenges and limitations. And of course, this is a very important issue, and that's why we went ahead and we supported also. But as I said, if localities can come forward and take some part of that responsibility and not just leave whole financial burden on the government, I think that would really help us to move forward in implementing that second part of the MRSSA Act, sir. So therefore, sir, I don't want to read the reply that was made by the department. It's a long reply. I thought it's better I speak directly on the issues that are there and address the concerns of the honorable members. And I hope, sir, with this explanation, I have been able to satisfy the concerns of the MLAs and the Leader of Opposition. As correctly mentioned by them, there is nothing that's perfect. There is nothing that is 100% that is going to be working fine, but it's our duty to try. And let me assure them and the whole House that government is leaving no stone unturned in the process of doing this, and we will continue to do this, and we'll assure the House that while we work towards finding a solution for the entry-exit gates, which will stand the test of judiciary and the scrutiny of judiciary, we will continue to work towards ensuring that the second part of registration and involving the localities continues. So this aspect and this thing is what I wanted to clarify. And with that clarification, sir, I would like to request the mover of this resolution to withdraw this resolution. Thank you, sir.
Mr. Speaker, sir, before I express my mind of withdrawing or not withdrawing the resolution, I would like to, at the very outset, thank the Honorable Chief Minister for being very exhaustive and for being pertinent to the points, which comes as a kind of hurdle in the whole process of implementation of this very important law that this August House agreed to pass, and it has become an act. Now, we know that there will be challenges at the time of implementation because the whole provisions of this act itself has certain components where certain sense of restriction of people's right, fundamental rights will be perceived during the process of implementation. This challenge was discussed exhaustively, but here one thing is that this law actually is designed, if we go by the intent, so that it will be an enabling moment for us to understand how we should move forward to give fruition to the objective in a manner where probably we have to come back to this August House to have the appropriate amendment, for which I think a healthy discussion will always be important and necessary. Here, to give an idea, is that the initial intent of the Act was to ensure the safety and security of the citizens of the state by preventing anti-social elements from gaining shelter in the state, which might be detrimental to the peace and tranquility, to maintain public order and peace, to verify and regulate the tenants residing in rented houses in the state, to establish district task force and facilitation centers, to facilitate effective enforcement of various laws for safety and security of the citizen and for matters connected therewith or incidental thereto. Therefore, this facilitation center and other measures are not to work in silo in as far as the mandate of the law is concerned. We have Foreigners Act 1946 and various other laws which is now to a great extent subsumed in Immigration and Foreigners Act 2005. But there are a number of laws. So while implementing, like we have the infiltration check gate. In Garobada we have, in Barnihat we have. So these are by virtue of the mandate of the existing laws which are enacted by the parliament. So how we synergize our endeavor. So therefore, if the court's observation was probably without giving, because sometimes we have to also know how to defend certain cases when we are subjected to judicial scrutiny. But having said that, what I can understand is that the observation of the Honorable High Court is very specific, that in absence of appropriate parameters, the parameters in the law, in the act, so that can be examined and appropriately amended. If the court observation was 2022, now this is 2026. So therefore, my concern was that, okay, maybe the government doesn't want to really look at this space which is available for the House to come back and give that kind of whatever is required to be considered by this August House to ensure that these provisions can be effectively enforced. And whatever is felt necessary to achieve the objective of the broader perspective, which is the collective intent, collective desire of the people of the state. Since we are lawmakers, I think we only understand as to how we should effectively fulfill our responsibility as lawmakers. Any law, but another thing is that at least this act, per se, even if we look at the observation of the MHA, Government of India, and the observation of the Honorable High Court, it has withstood the judicial scrutiny. It has, but only certain provisions in respect of the implementation of this facilitation center only. We use the word facilitation center, and if we look at the mandate to the facilitation center is also to a great extent to ensure that we are actually facilitating, we are not restricting. So how we dovetail the languages and nomenclature in the expected measures to further amend and give effect to this intent of the law, I think this should be something which the government should look at. I would like to, through you, Mr. Speaker, sir, let us have a collective endeavor to see wherever needed for amendment and to give effect to the intent. It will help to a great extent because the multiple laws are there. How we implement those laws. Now, even if we want to really identify areas to restrict, if we go by the earlier law, Foreigners Act 1946, Section 3, subsection 2 of subclause, I think it is E. Anyway, it is in Section 3, where the restriction of movement of the foreigners are vested with various authorities. That's the reason why we have the infiltration check gate. Now, how many infiltration check gate we want to have and how we create that infiltration check gate, and also in respect of enforcing other laws which are passed by parliament, which is beyond our legislative jurisdiction, and aggregate this, integrate this, I think that is how it can be designed. So with this observation, Mr. Speaker, sir, I would like to thank Honorable Chief Minister, but the fact that after having seen the observation of the Honorable High Court in 2022, I think lots of time has passed. And I agree that various other, rather beyond Shillong and beyond the Khasiat's region, this particular provision, other relevant sections of the law, which will ensure us to regulate the stay, entry, and uncontrolled entry and stay, unregulated stay, because that is where the main intent of the law is. I was referring to the challenges of the illegal immigration of nations which have got such a stringent immigration laws and measures, yet they suffer from the problem of illegal immigration. Because after entering, what they do, whether they go back, whether they return to their respective nations, that is the challenge. Here also, after entering, whether they stay or not, how we regulate through this mandate of the law, I think it is quite comprehensive. Further, more effective teeth we want to give, I think that can be examined, but it is necessary to not wait for any further. But I would like to, through you, Mr. Speaker, sir, urge the government, urge the Chief Minister to really look at expeditious endeavor to discuss for further amendment and to see that all those observations of the Honorable Court and the judiciary can be overcome through an enactment of law. Law and order is a state subject. That's why we say that it is for safety and security of the resident. Therefore, I think there's lots of space to navigate as to how we nomenclature the words that will be incorporated in any amendment and the existing law. So with these few words, Mr. Speaker, sir, I would like to just get a categorical reply from the Honorable Chief Minister and assurance that at least this needed effort will be forthcoming from the government.
Sir. Mr. Speaker, sir, thank you. I would like to thank the Honorable Elo for his positive suggestions, I must say. And as mentioned earlier, sir, that there are two important objectives that are there. The first, of course, is the registration and the task force and activating the villages and the localities, which is an ongoing process. And I assure the House and the Honorable Elo that this will continue in a much more aggressive way. But we look and we seek for support from local MLAs as well as from the traditional heads and leaders to work with us to achieve that. In the second part, sir, in fact, MHA has asked us to relook into the aspects of the MRSSA. So we have been given a mandate, I should say, by the MHA, saying that you need to relook into this MRSSA. So therefore, we are in fact working from the law department and our respected AG and of course the home department. So we are all, and the political department of course, so we are all working together in this and trying to exactly navigate through this entire very complicated web of laws and rules and counter rules and national level parliament rules and state rules and constitution, and seeing how we'll be able to achieve our goal, keeping all of these factors in mind. And that's the reason why we thought that the entry-exit points could be then validated through a law, which is the Foreigners and Immigration Act of 2025, having restriction and restricted area conditions put in, and then we would be able to activate the entry-exit point. So precisely that's what we're trying to do. But definitely we'll welcome suggestions, and if this requires us to engage with our political parties, we will welcome that, and we will have a session where we will discuss, or multiple sessions I should say, where we'll take suggestions from the political parties on this matter and see how we could navigate and figure out how the MRSSA could be amended and be given more strength. So all, as I said, sir, our intent is the same. We are all on the same boat in this particular objective. And let it be very clear to the House that we are very open to suggestions. We are very keen to find a solution. We have faced a lot of difficulty and challenges because of multiple reasons, but we are slowly and steadily moving forward. But as I said, I assure the House that we will definitely re-examine the entire aspect and see how we could bring in relevant amendments in the MRSSA, which would, again, as I said, stand the scrutiny of the judiciary as well as of the Government of India and the Parliament. So with this assurance, sir, I once again would like to urge through you to request the Honorable Elo if you can withdraw the resolution.
May I know the mind of the mover of the resolution, whether he wishes to withdraw or not withdraw?
Mr. Speaker, sir, my mind is very positive. I would like to say thank you to Honorable Chief Minister. Today's discussion pertaining to this very important resolution is definitely a reflection of the collective resolve and intent, and it proves our collective sense of responsibility towards this very crucial issue that we need to deal and address. So we look forward for all those collective measures. During our time, we did discussion with lots of stakeholders and all. I think that's how we were able to get the complete unanimity in this August House at that time. So with this observation, with this positive observation, and my power of anticipation, which says that, yes, we will overcome, I think I take this privilege to say thank you to the government and withdraw this resolution. Thank you, Mr. Speaker.